Litigation over Avoyelles Parish's home rule charter is now in the hands of the state's highest court. Alina Noakes joins me in the studio to break down what that means for the case. Alina.
Yeah, Brooke, it's the end of the business day and the state Supreme Court has not made a decision yet on whether or not it will take up the home rule charter case coming out of Avoyelles Parish. But time is ticking down on the issue altogether as litigation over the historic process continues to play out. On July 7th, the Third Circuit Court of Appeals kicked the case challenging Avoyelles Parish's home rule charter petition back to the parish court. The ruling came after Avoyelles Parish Judge William Bennett ordered the Avoyelles Parish Police Jury to call for an election of commissioners to write a home rule charter, an order the police jury appealed. Per state law, the police jury is required to call an election since the parish registrar of voters certified the petition met the requirements needed to tell the police jury to do just that. So far, the police jury has refused to, arguing the petition is invalid. In fact, the police jury even filed suit against Gloria Morrow, the registrar who certified the petition. But the lawsuit against Morrow came a little too late, just the day before the case went to court before Judge Bennett. In his ruling, Judge Bennett found the deadline for putting the commission on the fall election ballots to be more pressing, and waiting on sorting out the validity of the petition should not get in the way of that. In appealing Judge Bennett's ruling, the police jury argued the judge was asking them to do something illegal. The police jury claimed the petitioners did not follow the law when gathering signatures, even alleging they paid people to sign it, and argued they were not allowed to submit evidence, call witnesses, or question the registrar in court. The Third Circuit rejected all of those claims, finding the police jury's attorney, Stacey Alzine, didn't even attempt to submit evidence or call witnesses. And since the registrar had been sued and not yet gotten representation, Judge Bennett limited both the petitioners and the police jury from questioning Morrow. Even though the Third Circuit came to those conclusions, they vacated Judge Bennett's ruling that the police jury must call for the election. That's because only Morrow's certification of the petition had been submitted before the court, not the petition itself. And that's the reason Glenn Goudeau, the petitioner's organizer, has sent the case to the state Supreme Court. His attorney, Danny Garrett, argues Goudeau does not have to prove the registrar properly did her job, and the Third Circuit is putting an undue burden on Goudeau in requiring that. In his request to the state Supreme Court, Garrett gives three primary reasons he believes the High Court needs to rule on the case. He argues there is no precedent for home rule charter litigation, as this is the first time a police jury has ever been successfully petitioned to call an election, much less challenged it in court. Plus, with the election deadline approaching, Garrett believes timeliness is a factor. The Secretary of State says the last possible day to get the commission election on the fall ballot is August 1st. If the litigation isn't resolved by that date, the election would need to be pushed to the spring, which would come at a great cost to the parish, an estimated $150,000 or more. Again, the Supreme Court has not yet made a decision on whether or not to take up this case. We're going to keep you updated as we know more. Brooke?
All right, thank you for that, Alina.